So when Chris asked me to moderate this panel with, two of the smartest people I know on this issue, the first thing I thought of was when I was home in Illinois, I heard about that Google Art thing a few years ago, where you could figure out your doppelganger from some like ancient medieval or Renaissance painting. And I wanted to see who I looked like. So I pulled up the app and I'm like, I somewhat work on tech policy. I should be able to figure out an app and how to get this thing to work. And I eventually found out when I got back to DC that it was like illegal in Illinois because of their data biometric privacy protections. So that was the first thing that got me thinking about this, and I haven't done much thinking on data privacy since. So I'm looking forward to learning along with all of you from Neil and Berin. And in case you don't know, we have Berin Szoka. He's the president and founder of TechFreedom, which if you don't follow their work, they're one of the go-tos when I need a quick answer to some question someone asks me about almost anything on the federal and state level tech policy related. And then we've got Neil Chilson, formerly from the FTC, but now a senior research fellow at the Charles Koch Institute for their technology and innovation portfolio. Mm-hmm. But the first question I wanted to ask is, why are we here? Why are we talking about state data privacy protections? Berin, do you want to start?
Well, first, I just want to note that Jared still holds the honor of being having the most appearances on the Tech Policy podcast, up to probably 37 or so.
I don't know, where's Ash?
A lot,
yeah.
A lot, which is pretty remarkable given that the issues you work on are not really issues that we work on.
Yeah.
Well, which is great, because we cover a lot of issues, and if you haven't subscribed already, lovely Ashkan Kazarian here is our host, took over the show, as you may know, from Evan Swartztraber, so the Tech Policy podcast, easy to find, easy to remember.
New and improved under Ash. Compared to
yeah, don't get me started. Greatly improved. Evan's not here, so I can say that. Yeah. And even if you were here, I would say that anyway.
That's right.
So data privacy or data protection, right, which is, I think, a broader term. We'll talk today about what that actually means, but it's an important subject in itself. It's also a good way to start understanding the way that consumer protection law works in America and the federalism issues that it presents. So this has been a recurrent theme of the day about where the line is to be drawn between federal and state authority, and sometimes that's a literal line, like in the airspace, it was literally drawn at a certain height. You got the same debate about drones, where do you draw it? We're now seeing states try to regulate internet services, both to replicate the FCC's 2015 net neutrality rules and also the privacy rules that people want to see enacted at the federal level. So in the absence of Democratic majorities in Congress who could pass legislation, or even when there were Democratic majorities in Congress and a Democratic president, there was no legislation passed or even seriously moved in Congress. So states are now trying to regulate on their own. California has now passed both a data protection bill and a net neutrality bill. And that's forcing a conversation both about what the federal government should do and also where the lines are for what states can and can't regulate. My colleague Graham this morning gave his presentation of his paper about the way in which when federal law has spoken to a particular issue, that preempts the states from being able to regulate in that field. And there are federal laws on certain aspects of privacy. The federal government has taken a what some call a sectoral approach. I would prefer to call it a more flexible approach, where we have a generally applicable consumer protection statute, the Section 5 of the FTC Act, that applies across the board to all matters of consumer protection without specifying any one particular matter. And the FTC, regulates on a case-by-case basis and crafts rules without going through the regulatory process, but they're still rules. When they declare a practice unlawful, that is a kind of rule. Congress has enacted a series of statutes to deal with specific issues like credit reporting in the 1970s, children's privacy. There have been a few other specific enactments. That's the federal approach to privacy. That preempts the states from dealing with those specific issues. But even in the absence of specific federal law, there are important constitutional limits on what states can do in regulating what are inherently interstate media, as the internet is. So we're going to see litigation over these state efforts to regulate. And you're seeing now in Congress a discussion of, the Attorney General mentioned GDPR. Not everyone in the audience perhaps follows privacy very closely, so you may not know that that is the general data protection regulation that was just enacted by the European Union, which replaces a previous, more flexible approach to privacy that the European Union had and now has a single set of regulations for the entire European Union. So between that and the state regulation, most notably in California, you're seeing a lot of pressure in Congress to finally take up the issue of privacy legislation, something that the Federal Trade Commission first asked for in 2000 and has been tossed back and forth in DC without really a lot of light being shed on the subject. And Neil will talk about this, so I don't want to steal too much of his thunder, but everyone talks about privacy, but privacy is like a continent-sized generalization, right? And what you have to think about are the little details, all of the small things. So just as a continent is full of towns and villages and a variety of geographic features, privacy is full of an infinite almost number of specific fact patterns and things that we worry about. And the question that lawmakers are now facing in states and in Congress is how do you deal with those? Which of those can you deal with specifically? Which of them do you understand well enough to make a rule about? And which of them do you want to deal with under more flexible standards? So that's sort of that wasn't, I forget what your question was.
Well, it was why are we here?
Good introduction.
I'll answer it, it's fine. No, you asked why we were here, and I think there's a lot of reasons, and Berin touched on most of them. I'll just say, obviously, privacy is an issue that concerns consumers, and it's an issue that's been in the news a lot, and so I think that lots of state legislators are interested in doing something about it. I will say that often, and part of the definitional problem, one of those states in the continent of privacy, possibly, or maybe it's inverse, is data security. These are not the same things. Securing data and having privacy are not the same things, and so it's just another example of the complications that state legislators and federal legislators and regulators are facing when they try to figure out a way to address these popular concerns about how data is being used.
And are the concerns over things like, Google Plus, rest in peace, like their leaks that just happened, or is this something where it's about just the accumulation of data that companies are able to have now? Where do you see the concerns coming from?
So, the idea of privacy as a legal right is quite old. I think there's the seminal paper in it was by Warren and Brandeis. It's called The Right to Privacy. It was written in the early 1900s.
1890.
1890, late 1800s. The basic idea there was that privacy is about the right to be left alone. That was an early definition. The definitions you hear nowadays are more, especially if the sort of European conception of privacy is much more about a right to control. And I think the thing that's really important to understand about privacy is that when we're talking about privacy, if we just think about it in a very abstract way, privacy is a restriction on how somebody else can use information, can collect or use information about me or about a consumer. Those restrictions can be, physical. We could, lower the blinds so that the photons bouncing off of me don't go out the window and people can't observe them in the street. That's a very practical way to stop somebody from collecting. They can also be technological, encryption, or they could be legal, things that say, well, I don't care if you collected it or if you observed it, you're not allowed to use it in this way. The important thing for policy to think about there is that means that privacy is a restriction on how other people use information. And that means there's a balance that has to be struck between the interest of the party that the information is about and the interest of the party who is using information. And this gets even more complicated because often the information that is about me is information that I myself did not necessarily generate. It might have been generated through an interaction with somebody else. So sort of like this conversation right now, is this my information, the fact that I'm talking to all of you? Do I have a right to stop you from taking this information that I was at this location or that I said these words and taking it out? And if you ask me a question, do I have the right to, or do you have the right to stop me from taking that question and mentioning it to my wife that somebody asked me a question at this panel? So the important thing to think about is that if we move into the legal space, restrictions on privacy are restrictions on how other people use information. And therefore, we have to figure out the right way to strike the balance, and it's a challenging balance, especially because consumers have lots of other interests. And in the US, at least, we have legal protections around the use of information around the First Amendment, for example. And so my right to say something and your right to privacy might come into conflict sometimes.
So this is a great place to start, because when you talk to people, especially in the free market community, who are not privacy experts, who are trying to figure out what to think about this topic, almost inevitably, they always want to apply a property rights-based framework to the topic. Because they think, well, property rights work great for the rest of the world, so why don't we just propertize personal information? Well, for all the reasons that Neil has just identified and more, that breaks down almost immediately in practice. And if you want to read more on this, I would recommend to you Larry Downes, one of our favorite authors, wrote a great piece for Cato on this several years ago called A Rational Response to the Privacy Crisis. Really just demolishing the idea that you can effectively propertize information, or that a control-based framework really makes sense. And instead, what the US approach to privacy has always been, in part because of the First Amendment, has been to focus on the potential for abuse and harm, right? And so in the United States, we've had these generally applicable consumer protection laws on the books, in the case of the Federal Trade Commission, since 1934. The FTC, as Attorney General Reyes mentioned, the Baby FTC Act here in Utah, which was essentially replicated from the FTC Act, just as many other states did in the 1960s at the FTC's encouragement. The FTC has broad power to punish deception, which is outright lies, but also omission. If you omit to mention to consumers information that is material to their choices, that could be a consumer protection problem. And so you asked about Google+. So you may have heard today that Google+, the very wildly successful Google social network that was used by literally all of Google's employees and several other people, they had a technical snafu in the early days of their program that allowed third parties to view information by not just the people who were using their app, but the friends of people who were using their app, right? So in that sense, it's analogous to, or somewhat analogous to what happened with Cambridge Analytica. Well, Google Plus decided not to disclose that, and we don't know all the facts, but it appears that they made the decision because no one actually accessed that information, so they say that was part of their calculation as to why they didn't want to do that, and that they weigh risks as to when you disclose a harm because that may expose other vulnerabilities and so on. I don't know what the right answer here is, but I will tell you that having a rule about disclosing every single thing that happens, every single sort of vulnerability like that, does come with costs. It does create the risk that you unduly alarm consumers, that you perhaps alert people to other potential vulnerabilities. On the other hand, consumers may really want to know. That may be a material decision. It may be that Google should have told users that so that the dozens of other people who were not Google employees who were using Google Plus could have made an informed decision about whether they wanted to do so. I don't know what the right answer is, but it's a useful example because it illustrates that you don't have to have a specific rule on the books that says you must disclose every single breach within X number of days if you have a generally applicable authority that, as the FTC does today, says that if something happens and it's material and we can decide after the fact whether it's material and you fail to tell consumers, that could be an unfair trade practice, or a deceptive trade practice. So that's deception. Unfairness is even broader. It says, doesn't matter whether there was a statement, doesn't matter what you said. If consumers are harmed, if there's more harm than benefit, and the consumers couldn't reasonably avoid that practice, that can be an unfair trade practice, right? Well, that's given the FTC broad authority to police data security and privacy. And I have my concerns about how that's been implemented and how much notice, and Attorney General Reyes mentioned this in his speech, how much notice is given to companies as to where the lines are and how much they need to do to secure data or what their practices should be. But as a baseline approach, I think that's the right one. And my hesitation is, now we're talking about legislation and how to encode in statute more specific rules. And sometimes that makes sense. So for data breach notification, where you know that data was taken, I think 49 states now have their own data breach rules. There is broad support for a federal standard to govern that. I don't necessarily have a problem with that. That's a part of the continent that we know pretty well if you're thinking about the early days of exploring the Americas and we're starting to sketch out what the map looks like. We know that part of it reasonably well. We could put that into regulation. We could give the agency civil penalty authority to penalize violations. But not everything looks like that. And unfortunately, Republicans are very far behind Democrats in thinking through their approach. Democrats have thought about this a great deal. They have a variety of opinions about this, but if you got a bunch of people together in the room to talk about what Democratic legislation should look like on privacy, it would be a pretty packed room. Republicans, frankly, really haven't thought this through. To the extent that they have engaged in this topic in Washington, it's been very responsive. It's, oh, California has done something, maybe now we should regulate to try to preempt, or you might have heard about the brouhaha about the broadband privacy regulation. I won't bore you with this, but suffice it to say that when the FCC in 2015 took over jurisdiction over broadband from the Federal Trade Commission in order to issue its own net neutrality rules, that also necessitated the Federal Communications Commission doing something about privacy. They decided to issue a set of rules. That was pretty heavy-handed. It applied unique burdens upon broadband service providers. The Republican Congress canceled those rules in 2017 through the Congressional Review Act, and that left open this huge political debate about what rules should govern privacy. Marsha Blackburn, Republican, as you might have noticed, introduced a piece of legislation that essentially said, well, we'll take those heavy-handed rules and we'll apply them to everyone so it'll be fair. Well, that's not a very thoughtful approach either. That was the Browser Act. So now Republicans are trying to figure out what to do, and we have two efforts underway. The NTIA, which is the essentially administrator of spectrum, but also of policy for telecommunications and the internet, has started a process to take comments on how to regulate privacy. That's open now for comment through this month. And Senator Thune, who's the chairman of the Senate Commerce Committee, has indicated that he's going to propose his own legislation, which will be really the first time that any Republican in a position to do anything about privacy has tried to come up with their own bill. So that's why this is a really critical time for this issue.
And Neil, do you agree with Berin that we should, that states should use their mini FTC authorities and just the FTC's powers in general to try to fix this problem, or how they view it as a problem? Or do you think there's legislation that should be passed at the state level as well?
Well, I think that the U.S. approach on privacy has been pretty successful. Just outcome-based that we see as far as innovation, just the natural experiment. Berin mentioned that there's previously to GDPR in Europe, there was another law that was more flexible than GDPR, but that's not to say it was particularly flexible. And
what, so with GDPR, we understand it's the framework that Europe put in place.
Yes.
That if you're on the free market side in America, you should hate it. But what are like the top 3 terrible things that it does?
Well, backing up from the substance of GDPR, just big picture, the top negative thing about the GDPR approach is that it tries to predict the future ahead of time. I guess that's the only way you can ever try to predict the future is ahead of time. But it tries to predict the future and then pass a law that will address every single situation that might come up. And what it does is it sets out exactly how companies should do a bunch of different things. Now, there's a lot of, it's a big, complicated law, and there's a lot of different requirements in it.
Such as those annoying pop-ups whenever.
Sure. So telling you that they use cookies, for example, or that they collect information every time you go to a website. These are based on the ideas that are pretty long-standing in privacy approaches of notice and consent. That we need to tell the consumer about the types of information that we're using and get their consent of some kind. And in the U.S., we've tried to draw those lines between opt-in and opt-out, just setting the defaults correctly, right? And that's based entirely in the U.S. on the sensitivity of the information and the likelihood of that information causing an injury. And so the U.S. approach is not ahead of time trying to predict what's going to happen, what harms might come about, what benefits might come about, but it's looking at the ecosystem that develops and saying, where are there injuries? Where there's injuries, let's get redress for consumers. let's bring cases against companies that stop that behavior and send a signal to the market about what things are probably improper and probably will harm consumers. And the reason this approach works better, in my opinion, is that we know that consumers have widely varying preferences on privacy. Some people want to post, everything that they do online constantly.
Yeah, I'm live streaming this.
Right. Yeah, perfect. You're live streaming this, and some people want to play video games and broadcast that to everybody that's out there. Other people are much more private. They want to contain the information about them. They don't want to share that. And we know that consumers' privacy preferences are widely varying. So when we take a law and we say, well, we're just going to draw the line here, right? And we're just going to put it down here, and we're going to say, this is what everybody has to do. These are the choices. This is a set of choices that everybody's going to face. What you do is then you take away a lot of flexibility, because the important thing is that consumers don't just care about privacy. They trade privacy off against lots of different things. They care about convenience. They care about price. They care about efficiency. They care about the fact that the product works. They care about security. And so if by a law you're making those trade-offs for all consumers on average, you're probably going to draw that line in the wrong place for a lot of people. And so what an enforcement-based approach does is it says, we're going to find out where actual injury occurs, and we're going to address that, rather than trying to predict ahead of time what would be the best for everybody on average. And so that's my main concern. There's lots of things in GDPR that the result of that is that sort of approach is not only that it's bad for consumers, but also it's expensive. It's expensive to comply with. It's very expensive to comply with. And that has the somewhat perverse effect of adding a benefit for big companies who can afford this and making it very difficult for small companies. And so small companies, essentially with GDPR, I've talked to some of my friends who advise people on GDPR compliance, which is a growth industry for lawyers, but not in innovation anywhere else. And they basically say, here are the 5 things that if you're a small company, you should care about, because they're the ones that you're most likely to get in trouble for. But there's no way you can comply with everything, so don't even try. Just focus on these 5, and hopefully they won't notice.
So then, if I understand you, you're saying any state attempt, or not, well, most state attempts to try to fix this through legislation would end up with like a mini GDPR in some way. Like, do you?
Well, I think there's probably approaches. There's certain targeted approaches, and again, it gets back to the idea that Berin said that privacy is a continent. So you probably don't want to just do a privacy law. You probably want to find out what your actual problem is. Is the problem about banking data? Is it about health data? Is there some specific use that you're seeing over and over that you're bringing enforcement cases about and that you need to address with a prescriptive law ahead of time? That might make sense. So some targeted things, but trying to solve all privacy problems through a single bill is probably the wrong approach.
Is that what California tried to do then, Berin?
Yeah, so the rhetoric around this is really instructive. For now 18 years, the debate has been about whether we have a comprehensive baseline federal privacy legislation. Well, in my view, we already have comprehensive baseline federal legislation. It's just not privacy specific. It's Section 5. It's a consumer protection law. It's a very robust one. Trying to craft a comprehensive rule for an entire continent when you don't know what it all looks like, it is clearly a mistake. As a procedural matter, look, the European Commission, whatever else you may say about them, they're very well resourced, they have lots of staff, they worked on this very hard from some misguided premises, and it took them years, and it was a very complicated effort. And so if you contrast that with what happened in California, the only reason the California law passed is because a very wealthy person had managed to get onto the ballot in California in their insane form of Athenian democracy for 33 million people, a ballot referendum that no one really understood. I mean, it was over 10,000 words long. I didn't really understand
On the
it.
ballot? It
Yeah.
was, oh, geez. Wow.
I mean, this is, right, this is,
I got confused on the DC tip minimum wage thing, and that was like 2 sentences. And I work in policy.
Well,
so that was,
and so the alternative to that was, well, let's just rush something through the legislature and we'll write it in 2 weeks.
Yeah.
Right? So look, states are not,
1 week.
frankly, I don't think that Congress is really up to the task of writing privacy legislation. So when I say that states are not, I don't mean to demean or denigrate anyone's ability. This problem is too hard and too complicated to be resolved in any rushed fashion or at any state level. And what I've told policymakers in Washington is really what we should have, the only way I see out of this debate, because this is just going to go on and on, in my opinion, is to have an expert commission to really study and recommend options. And I see 2 ways of doing this. One would be to have something like what Congress created about 10 years ago, which was the Antitrust Modernization Commission, which was a bipartisan vehicle set up by Congress to produce, in the end, they had a minority report and a majority report about how to modernize the antitrust laws, right? It's a hard topic, you need experts, you're not going to get that from congressional staff, and Congress understood that. That would be one way to do this. And the second would be that the NTIA process, which I mentioned, could be a vehicle for thinking this through. The Obama administration went through such a process. They, in 2012, produced a white paper of trying to distill the American approach to privacy. I think it was pretty thoughtful, and I didn't actually have any major disagreements with the high-level description of what it should do. The question was about how to operationalize that. They then spent 3.5 years struggling, in part because of the Snowden leaks and losing all of their credibility on privacy. But they spent 3.5 years trying to figure out what that legislation should look like, and it never went anywhere. These are hard questions that really, I think, need to be resolved through that sort of a thoughtful process. And I'll just give you an example of the kind of thing that lawmakers need to work on that is handled extremely poorly in the GDPR. It's the #1 problem with GDPR, in my opinion. And it illustrates just how even when you're trying to be comprehensive and detailed and predict the future and deal with every problem, inevitably you're going to just have to take a pass on hugely important issues and leave those up to the discretion of the regulator to figure out. And so here's the question. What data is in scope? Right? Any approach to any privacy regulation has to ask that question as a threshold matter. Well, GDPR says, well, anything that can be identified to an individual. So if you anonymize the data such that it could never, ever conceivably, remotely, possibly be tied back to an individual, it's not within scope, and you don't have to deal with GDPR. So huge sigh of relief, except that how do you know that you've actually done that? And then what do you do with all the data that has not been 100% absolutely definitely anonymized, but has merely been de-identified, which means that there's some risk that someone could re-identify it because you haven't removed all of the personally identifiable attributes, and someone could piece back together who that person was who conducted the following 20 searches over a period of time, et cetera, right? Well, GDPR doesn't tell you anything about how to deal with that problem of de-identification, but anyone who's taken any economics can figure out in the course of less than a minute that's the central problem. If you're in a company and you collect data and it's useful, and you have to decide, well, do you discard all of it when you're done with it? Do you try to keep some of it? And if you do keep it, do you even bother trying to de-identify it? Well, if the law basically says that if there's any chance that if it could be re-identified, that you're subject to the rules, well, you might just decide, you know what, I'm not going to bother trying to de-identify it. I'm just going to keep it in fully identified form forever. I'll get the user's consent, and if I'm Google or Facebook, fine. Then, they're going to consent to, frankly, whatever I ask them to do, frankly. So, if that's the approach that regulators take, what have you accomplished? You haven't protected anyone's privacy. You have discouraged the responsible de-identification of data, right? So that's scenario one. Scenario two is companies try to do the right thing. They try to say, well, we have to keep some of this data for a certain period of time, and we realize there's some risk, but we'll try to de-identify it, but then we're at the mercy of the regulator who might come after us, right? And so that's just an example of the kind of problem that we're dealing with. These are hard, essentially economic questions, but no one wants to think about them in economic terms or to think about them in terms of trade-offs, because in Europe, and for a lot of people in the United States, they begin from the premise that privacy is a right, and it's about control. And so we can't even have these conversations about trade-offs because that's such a heartless American way to look at it. Well, it's just realistic. And if you're not realistic about it, you end up, I think, ironically, undermining people's privacy by creating those sorts of perverse incentives to just keep all data forever. So this just illustrates a little bit of how hard this problem is and why, at worst, this should be dealt with in federal legislation. But the states really, should, in my opinion, stay out of this and really stick to their knitting, which is bringing clear-cut cases under essentially the equivalent of the Federal Trade Commission Act. There is a role for that. There are small actors. I mean, GDPR covers every grocer in Europe, especially essentially any company that collects any amount of data about users. In the United States, all sorts of companies, mom and pop shops collect data about users. And there is no way the Federal Trade Commission can police every single one of those companies. So your states, their AGs, whoever else is empowered to enforce the Baby FTC Act, they do have a role to play in dealing with these data protection issues on a smaller, more local scale. And I would never say that they shouldn't bring those enforcement actions against, maybe it's a car dealer that collects data and doesn't monitor how it's used and leaves it available for anybody to see when they walk in or doesn't secure their systems. I mean, in principle, those are cases that they could validly bring. I just don't want them trying to go beyond that and prescribe in regulation what the right answer is, or as Neil says, try to predict the future.
Yeah, and also, Neil, given your time at the FTC, can you talk us through some of the actual harms you were able to see to consumers because of companies mismanaging data protections? Like, what is animating the reasonable people on the other side?
Right. So I would say that's a great question. I like how you framed that. I was like, what reasonable people?
You can go to the unreasonable ones.
No. But there are a lot of concerns around. There are harms from violations of privacy, for sure. And the biggest approach that the FTC had taken was using its deception authority. And that authority says, basically, if you make a promise to a consumer about how you're going to use the data, you have to keep it. Like, if it's the sort of thing that they would make decisions based on. And so most of the purely privacy cases, again, making a very clear distinction between privacy and data security, related but distinct concepts, most of the privacy cases are under that sort of approach. The idea that the companies said they were going to do X with the data, and they did not do that. A.G. Reyes mentioned a case, I think he was referring to a case called Nomi, that was about a case where a company made a promise, and in fact, the promise that they made was quite a bit higher than what they were actually legally obligated to do. And in that case, the FTC, for just pure jurisprudential reasons, because there was no evidence of any sort of injury, probably shouldn't have brought that case. But that was a deception case. It was sort of based on what was the promise to a consumer. In the data security space, the harms are very often, they could be financial. Typically, those are the cases, risks of identity theft, for example, or actual identity theft that takes place. There could be also safety concerns. There could be health and safety concerns. There could be, those are the types, health and safety concerns and financial have been the majority of those cases. And then there's been some more, let's call them adventurous cases that maybe tried to tackle more attenuative harms, more less concrete harms. And those cases, I think, typically there aren't a lot of them, but they have occurred. But the great thing about the case-by-case approach, again, is that you're not drawing a single line, right? You're not drawing a line in law that says, hey, this is how the law is from now forever. There might be a commission who makes a mistake, or makes a mistake from my perspective, and there's always an opportunity for a company who's facing a case to try to push back against that mistake and win in the future. Now, there's lots of barriers to that. It's not a perfect system, but it certainly is better than having a single law that the only way to amend it is to go to the legislature. Which brings me back to California. Yeah. The California process was crazy. So I think many of you in your states, you may face some pressure to take this as a model law. This was essentially I heard somebody refer to this in a different context, but the concept, you all know about the free rider issue where you can have people who didn't contribute to the system but benefit from it. That the California law was a case of a free driver, right? Where like essentially somebody with a ton of money basically decided this is the policy preference that I want to put into place. It's a free driver problem. And basically spent that money putting this ballot initiative on and then turned to the legislature and said, hey, I'll take this down if you pass a law that's basically the same as this. And that looked like a good deal. It looked like the best of bad options because ballot initiatives in California, once they're passed, very hard to change. Whereas at least if they passed a law, California could change it over time to make it better. And that law was hugely problematic, including had a huge number of typos, including my favorite, which is kind of like just jaw-dropping. There's actually a typo that, if you read it literally, it says that companies have to include consumer data in their privacy policies. That's what it says. I mean, clearly not what they intended, that you would have to include that data in the privacy policies. So lots of problems in that law. I think procedurally, you shouldn't be surprised that were lots of problems because the legislature had about 7 days to think about it. Very few stakeholders were consulted. It was the opposite of the GDPR in approach, which was a very long process. But bigger picture, again, the real problem here is that it was the perfect example of the biggest problem in the privacy space, which is imposing the privacy preferences of the few on the many. This was an approach where some people were very concerned about a very specific type of data use, and they wanted to make sure that that's how the world worked.
But even then, this McTaggart, the sponsor of the ballot initiative, I guarantee you that if you'd asked him to explain what the law did, he couldn't explain it.
He was a real estate developer.
So it's not just that he's trying to promote his own preferences or force them on other people. It's that it's a Gestalt approach. I have this Gestalt feeling about privacy that we should do more, and we should somehow protect consumers. So someone go out and write something for me that does that. And that's the problem. This topic is so amorphous. I mean, at least net neutrality, for all of the horror of the last decade that we've spent or more fighting about this, at least at its core, can be reduced down to a few relatively straightforward concepts. That's not true for privacy.
Yeah, and I would say that's the big difference. That's another big difference between data security and privacy. And in data security, I think people generally agree what they want the world to look like. A good world of data security is one in which there aren't unauthorized people who are getting access. There's not criminals who are breaking in, right?
Yeah.
In privacy, people really disagree about what a good world looks like. There are some people who essentially don't want Google and Facebook to exist. They just think those are immoral business models. And there's lots of other people who think those are great business models and they like to use them. And so I just feel like that's another thing that makes this problem so hard, is that people really don't agree on what they think the online world should look like.
And if I can give you an analogy,
Yeah.
this is very crude, but it's something like, we probably all agree that cars should be designed so that they don't explode frequently. And also so that it's relatively difficult for anyone else who does not own the car to just drive off with the car. Right? It's pretty straightforward. We get that. You can quibble about the costs and so on, but privacy is more like the speed limit. I mean, do you?
It's more like the color of the car.
Yeah,
or the shape, or the design, or the features.
It's everything else about how you drive, right? So to reduce that to one word is the problem. So if I could give you any encouragement today, it's to stop thinking about this as privacy. I mean, even we say this as we've been up here today, we say things like violate privacy. That's a really unhelpful framing, because it presumes that there's this clearly defined good, and then there are harms against that. That's just not what we're talking about. We're talking about trade-offs in terms of the ability to use data to build new features, to offer services to consumers. Look, Facebook newsfeed, when that first rolled out, people sued. I mean, there is an organization, the Electronic Privacy Information Center, that has made its entire existence suing or threatening to sue or trying to get the California Attorney General to shut down every new feature like that since the birth of the modern internet. right? There really are people who really want to try to stop that kind of progress, even the things that we generally come to accept and love later. That's not a debate that you can reduce down to some simple yes or no, except to say that consumers should be given those choices, and we shouldn't set defaults in a way that prevent people from innovating.
Yeah, well, I mean, if we don't stop progress, how will anyone ever have jobs? Am I right? But I guess
At least in Washington.
Back to your topic, right? Yeah.
one of the things I do at Foundation for Government Accountability is work with a lot of state lawmakers and getting them excited about sponsoring a bill or killing another bill. But what I've heard from Berin and Neil is we don't so much on the state level right now want to be pushing bills. What we want to do is convince them that the thing they're concerned about right now, data privacy, is already adequately being protected, or at least, even if there are problems, passing a law isn't going to improve on that.
So I agree with that, but that doesn't mean there's nothing that legislatures can do. Mm-hmm. So if I were a state legislature, what I would be doing is holding hearings and asking, is our Attorney General's office equipped to deal with these issues? How many people do they have on staff? Do they have a sufficient technical expertise to bring the legitimate enforcement actions that they can bring? Are they coordinating with other states? There is a multi-state task force for coordinating, and the FTC, for coordinating antitrust suits. Right? There's no reason that they couldn't do that for digital consumer protection issues. But the thing is, that is not the sort of thing that will tend to win a lawmaker, a state lawmaker, headlines or help them advance their career, right? This is the hard work of doing state government, of doing oversight and bringing people forward to ask, what are your agencies doing? Do you need more resources? How's it going? Rather than just assuming that the answer is to write the toughest privacy law in the country for X privacy issue.
Well, the other good news, though, is we do have Europe to point to, which I found very effective on many things, just saying you don't want to be like Europe or California, at least in certain red states that works well. So at least if you cannot be for anything as sexy as some big data privacy bill, you can talk about empowering the Attorney General to continue doing what they're doing and say the other side wants to make us Europe. But I think we should open it up for a few questions because, yeah, Berin and Neil know a lot more about this, and I want to see what's going on in your states or how you can, if you can think about a way to help it out. Yeah.
So I'm curious how you guys feel about the stuff that we pay for versus stuff that we don't pay for. I mean, mine on Facebook, I didn't pay for it. I'm there at their grace. But what about the stuff that I pay for?
You should repeat the question.
Yeah, so the question was about services that we pay for online versus services that we don't pay for. Well, I think from the FTC's approach or from an enforcement approach, I think that weighs into the injury, right? If you are specifically paying for a product and they're not delivering what they promised, that's an easier calculation, and you have dollar signs with it, right? So that's the kind of case that AGs and the FTC, it's easier case to bring, right? Cases where there's a sort of a contract, but it's essentially you trading some access to your information to get this service, and I often, a little bit of a digression, it's amazing to me that this ecosystem exists, right? This is information that nobody would have thought 15 years ago was useful. How I clicked through the internet, like, oh, that's going to be a thing that it empowers an entire ecosystem of content on the internet. It's crazy that's enough, right, to fund an amazing explosion of innovation on the internet, but it is, and so with those sorts of services where they're provided for free, where essentially it's your attention that you're paying with, the question there is like, what is the injury in some of those cases, right? Now, deception under the FTC law doesn't require injury to be a violation, but that does sort of prioritize, it does help agencies prioritize their attention, in part because you want to go after the cases where there is consumer injury, the most consumer injury, rather than the ones where there's less consumer injury. So,
but to put it another way, just because you're not paying for the service doesn't mean that there can't be a valid enforcement action.
Absolutely.
It doesn't really change the underlying legal analysis, but it does highlight that this is just one species of consumer protection issues online, And the FTC has brought cases where people are ripped off online or where their children make unauthorized purchases because of the way that the App Store was designed. Run-of-the-mill consumer protection. And I think we should deal with all of these problems in the same basic framework. That's just one species of injury. There are non-monetary injuries. They're just, as Neil notes, harder to define.
This may be a horse that left the barn a long time ago, but it strikes me when you're talking about a case-by-case approach rather than a predictive legislative framework. Is it possible really to create a more traditional common law regime with regard to dignitary torts, contract line? We have a rich history here that seems like could be drawn from, or would common law claims largely be abrogated by FTC regulation or state regulation?
Right. Do you want to translate that to non-lawyer?
Sure. So the common law approach, and in fact the early privacy approach was a common law approach, and there still are privacy torts. So common law approach is, I'm injured by a party, so I take them to court for a tort claim of some kind, and over time, judges, by looking at specific facts in front of them, the law evolves. They apply past precedent to new factual situations and general principles of law and precedent, and they come out to a conclusion, and then that goes into the system, right? This is a sort of emergent order approach that over time you can sort of write out what the contours of the law are, but no one person sat down and scribbled it down, right? And so I do think that a case-by-case approach, even at the FTC, it's not a perfect analogy, and I think Berin has criticized this analogy occasionally. It's not a perfect analogy to judge-made common law, but because it is an enforcement-based approach where there is a case, they have to show, they have to investigate, they have to find some facts, and they have to come to a conclusion specific to that case. It does have some of the elements and some of the benefits of an emergent common law approach. So I don't think that horse has left the barn. I think you essentially sort of describe the system as it is today, and in fact, the privacy torts do continue to evolve in legislation. A lot of the issues right now are around standing and some other issues that are very detailed, but that does continue to go on in the tort world.
But there are reasons why we have the federal consumer protection laws that have to do with effectively socializing the costs of enforcement, so we don't have to have everyone go out and bring these cases. Also, there are some hard standing problems, especially where injury is hard to define. I don't think you could really bring a suit in federal court today, and so the FTC is able to a degree, circumvent that problem by having a statutorily defined species of standing. So this is like the conclusion of Privacy 101 at the end of the semester. We get into that. Privacy 201 is all the problems with the FTC's approach, right, which we've been dancing around today, and I don't really want to spend a lot of time on, but suffice it to say that what we have been describing today is in principle how the FTC works. There are many questions to be asked about how it actually works in practice, and I am greatly disturbed by the degree to which the FTC's approach in practice has departed from an actual common law method, because the FTC almost never goes to court, and in the case of privacy and data security, has managed to regulate for 16 years with only 2 even partially litigated cases. So the FTC, it's like the common law, except the judge just makes it up as he goes. So there are some real problems with that. And
it's like the common law, except tort law has been evolving for 500 years, and we've had 15 years of FTC law.
Yeah, so. But it's like the common law, except that no one litigates, and it's everyone settles, and so it's not really the judge hearing expert witnesses on both sides, like say in antitrust law. It's the court just asserting what the law should be. So, look, one more thing I would say about this is that there are, even when we talk about data security, there are, if you want to simplify it, there are maybe 2 different buckets of practices or remedies. There are some things we know about pretty well at this point, right? Like, you probably shouldn't set passwords to be, 1, 2, 3, 4, 5, and you probably shouldn't send them in email, and those things are really straightforward. And at this point, those could be reduced into a regulation. The problem is that you can't reduce the entire species or the entire, if you will, state, to use our continent and state level analogy. You can't reduce everything into regulation because there are all sorts of other data security practices that you're never going to be able to predict. So this debate in Washington about should there be federal data security legislation or not, it's always going to be a hybrid of rules and standards, where the rules are for the things that have, with some certainty, been figured out. Like, you know, if you're going to email out to every single Prozac subscriber something, you should probably put them in the BCC field and not send it to everyone. Like that I think we could probably agree upon. But the hard stuff is the stuff that we don't know about. And if you want to really understand this approach, because as I said at the outset of this conversation, we've been talking about privacy today, but we could just as easily have been talking about product design and how user interface is configured online, all sorts of other digital consumer protection issues. If you're interested in this topic and you just want to understand more how to think about what we've been describing today or discussing today, I would really encourage you to go back and read the 1980 Unfairness Policy Statement and the 1983 Deception Policy Statement. They're very short documents. I think they're each 4 to 6 pages. They're not hard to read. They were written in some ways for a lay audience, that is Congress, and they explain how the agency thinks about these issues. And they would really be helpful for anyone who's interested in this topic, because in Washington, no one reads these. The congressmen, especially Democrats, constantly say, oh, the FTC's Unfair and Deceptive Practices Authority only allows them to punish when companies lie to you. Well, you know, obviously there's more to both of those things than just companies lying to you, right? So there's a level of ignorance about how we do digital consumer protection that it really wouldn't take very long for anyone in this room to get ahead of and to be more informed about for these discussions in the future.
All right, well, I think we're out of time now, but if you have any questions, I'm sure our wonderful panelists will stick around for a few minutes after. Thank you for your attention.